Hi, Troy Bix here with Jansen International with Restore, Rebuild, and Replace, R3. We are here with Jeff Greenberger. Jeff, how are you? Tell us a little bit about yourself.
Sure. Well, I'm a lawyer in Cincinnati, and I got into self-storage just with my old law firm. We had an attorney in the office, and she went to school with the guy who was the first person, we think, to build storage in Cincinnati. And one night, she went to high school with the daughter of this guy. One night at a party, she walked up to him and asked when she could have some of his business from the storage place. And he said, "When you can outdrink me." And she said, "I'm Sicilian, I can outdrink anyone." He said, "You can't outdrink a German." And no one really knows how that night turned out because neither one of them actually remember who won. But I do know that he gave some business to our firm, and the lady walked into my office a couple days later after sobering up and said, "You do similar landlord-tenant law. I need you to get involved in self-storage. We have a client." I said, "I don't know anything about it. I've seen them on the highway and stuff." But she said, "Well, learn because we've got a client." And I did. And this guy was very generous to me. And he didn't just let me represent his company, but he pushed me up sort of nationally and said, "You know, you've got a way of breaking things down that I like. And I think other people in the industry might like it too. You talk more sensibly and make it easier to understand. So let's get you some national shows." And the next thing I know, you, back in your old days, are giving me a break at ISS Magazine, letting me do some shows and some columns. And it's just sort of grown from there. And now it's probably about 80% of my law practice is representing owners and managers of self-storage facilities, trying to help them stay one step ahead of a lawsuit, whether it be from revising their rental agreements or advising on employee issues, or just like we're going to talk about today, just common sense stuff. What should you be doing with this big investment you've got that you probably think you're going to pass down to your children to keep it up? Because if you let it go too far, you bought yourself a lawsuit, you may lose it. I literally, as I told you earlier today, had a guy crying on my shoulder a week ago, afraid he's going to lose his business because he wasn't taking proper care of it. And now he's got a lot of potential for a lot of lawsuits.
Tell us about your firm today. What's the name of your firm today, and a little bit more about that.
Sure. So about 3 years ago, I broke off into my own small law firm, and it's called Greenberger and Brewer. It's in Cincinnati, and we have a commercial real estate practice, a couple other things that we do. I still represent a few friends that are doctors and other lawyers and so forth, but mostly commercial real estate. And like I said, on my end of the hall, it's a lot of self-storage work.
Let's move into the safety side of the industry, where it stands today. We do know, and we have data proving that close to 30,000 sites today are 20 years and older. Of that 30,000, about 15,000 are 30 years and older. So obviously we have some functionality, safety, and security issues. Looking ahead at liability, when there's an accident on the facility, what happens after that? What is that typically, who owns that liability?
Right. So there's three things I think we ought to talk about under that tent. The first one is just the straight liability, right? I have a case going right now where a lady rented a storage unit. As we know, 70% of the decisions made are made by women to rent. This woman rented a storage unit. She brought her boyfriend to help her move in. It was an older facility with a door that wasn't in good condition. He reached up to load something towards the back, caught his hand on the door, sliced his hand open. Tendons, the whole thing. Okay? So there's two problems, right? One, we're going to be liable for this injury potentially, right? And it's a pretty serious one. And it required emergency surgery and all sorts of other stuff like that. But number two, and the thing that I don't think operators ever think about, is we have a rental agreement with the lady. And it says we're not liable for her injuries and we're not liable for loss and damage to her property. We've got nothing with this guy. We're 100% on the hook for whatever happens to this guy at the property. Meaning, you can't, even if you think you've got a really good lease, even if you think you've really drafted solidly, you can't ignore things like defective doors, or doors that are so old they don't stay up on their own anymore, doors with sharp metal objects, doors with springs that are exposed. You and I both know people who've had their customers lose fingers in springs because they were trying to fix them themselves, because we've left them exposed because, you know, it still opens and closes sorta, so let's not invest in a new door. But the reality is that's really going the way of the dinosaur, right? If you're not going to keep up your doors and the other parts of your facility, you're playing a waiting game for the lawsuit. And the worst part is the lawsuit may not even be one that your lease helps protect you from. It may not even be one your insurance protects you from. So that's one. You want me to go on?
Absolutely. Let's hear it all.
So, all right. So number two is the risk of just what can happen at your facility, not even with doors and not even within the unit, right? Just what you could have prevented, right? When I got very early in my career, I had a case where a lady was sexually assaulted at a property, right? Lights at the facility weren't working, cameras weren't working. Doesn't matter, the cameras, it's not like there was some guy, you know, watching the cameras anyway at 9 o'clock at night. But the lady who rented thought all that worked. And that was one of the reasons the magic word is reliance, right? I relied on this stuff being here to ensure my safety.
The functionality.
Functionality, right? The functionality, not just of doors, but of cameras, of roofs, of everything. You showed me a wall of video screens. I thought somebody watched that. I thought the lights would work at night. I thought that, you know, I would be safe here. And in the lawsuit she filed, she actually called it a big cage, right? When you think about it, that's pretty scary, right? Once you're in and you're through that gate shuts.
You're locked in.
You're locked in, right? You get hit in the head with a door that falls, how are you going to get help, right? You got somebody chasing you around the facility that wants to do you harm, and it's not well lit and the cameras aren't working. That's all going to be Exhibit A in the lawsuit against you based on reliance that I thought you'd have this place safe and secure and working, and you didn't, right? And the third is the bailment, right? The care, custody, and control issue. And we'll talk about that more with your new locking system, but I want to mention it from a different angle first, right? The first way that it comes into play is with things like knowing that something isn't as good as it could be. If you've got a 30-year-old roof, there are going to be leaks, right? If you've got 30-year-old doors, they're not all going to stay up. They're going to be something that's going to harm someone, right? It's your job as the owner to present a facility that is safe, commercially safe. You've got that responsibility, and then you've got a responsibility to make sure that your facility is well run enough and maintained enough that you know, or you have no reason to believe, how about that nothing would be damaged within the unit, right? You got big gaps in the doors, wind, dust, rain, mice,
Water,
right? Guess what insurance doesn't cover if it comes in through the door?
Right.
Water, right? So now someone wants to file a claim against the facility. They say you had some duty to at least give them a unit that would have kept normal. I'm not talking about the 1,000-year rain, but the regular blowing rain that you get at an average facility in this country. You had a duty to present me a unit that you knew wouldn't leak that way, and you know full well it would if the wind blew the right way and the door gapped a little bit and the rain came in, because you've had 5 other tenants in that unit have water damage. You're liable, and the contract isn't going to protect you from that. So, you know, it's all those sorts of things that go into why is it important to maintain the facility. If you think we can draft around all of it as lawyers, as a lawyer, I can't. I can only get you to a point, and then it's got to be that you can't ignore the obvious stuff that would cause damage, that takes you to a different level and exposes you to liability all over again.